This is a lecture on Module 7, Protection of Civil Liberties and Civil Rights, an overview. Module 7 provides a broad overview of the Constitution's protection of civil liberties and civil rights. Most of those rights and liberties will be covered in greater detail in subsequent modules. Module 7 just skims the surface. In this lecture, I'm going to talk about several of the topics that are also covered in Chapter 7 of your textbook. But this lecture includes material that is not in your textbook. So it's going to be important for you to take notes as you listen. So in this lecture, I plan to explain the differences between civil liberties and civil rights. That is something that's not explicitly covered in your textbook, but it's an important distinction. I'll review the location in the Constitution where you'll find explicit protections for civil liberties and civil rights. I'm going to try and explain the legal precedents that pertain to gun rights, including some new developments that came about after your textbook was published. And I'm going to describe the general classification analysis that applies to civil rights law, but we'll go into greater depth with it. And there's a module entirely devoted to equal protection. And so you'll hear it again for this lecture and for this module. We're just wanting to get kind of a general overview of how it works. And then last, I'll briefly explain some of the limitations on Congress's power to legislate protection of civil rights. Okay, Chapter 7 addresses constitutional law decisions relating to both civil liberties and civil rights. And it kind of combines the two issues together in the way it outlines the material. But civil liberties and civil rights are not the same thing. They are analyzed differently by the Supreme Court. And so I think it's important to look at those differences, and I believe it will help you understand what you're reading. So there is a difference between civil liberties and civil rights. Civil liberties are individual rights. You can think of them like the unalienable rights that are referenced in the Declaration of Independence. All people are, in the words of the Declaration, endowed by their Creator with certain unalienable rights. The Declaration states, among them, so among those unalienable rights, are life, liberty, and the pursuit of happiness. But there is no official list of all civil liberties that individuals are endowed with. On various occasions, the Supreme Court has tried to give a definition of civil liberties, but no definition is perfect. So, for our purposes, consider civil liberties as simply the freedoms that an individual ought to have in a free country. In the cases you'll read, you might see them referred to as fundamental rights. That's another way of defining civil liberties, the individual rights that are fundamental to freedom. Bear in mind that these liberties, these fundamental rights, are enjoyed by all people. Their protection is not limited to just citizens of the United States. So our Constitution adopts a sentiment, essentially, of the Declaration of Independence that all men, not just U.S. citizens, all men, or the more inclusive phrase, all people, are endowed with unalienable rights that our government is obligated to protect. In the Constitution, you'll see that sentiment in its protection of the liberties of people. The Constitution uses that word, people, when it's referring to civil liberties. So the freedoms, these individual freedoms, civil liberties, are not the reward of good citizenship. They are natural rights, rights that all individuals have simply by virtue of their humanity. Civil rights are collective rights. The phrase refers to the obligation of any legitimate government to treat people equally, to not discriminate among various groups of people based upon their race, gender, religion, etc. The law cannot create a classification of people based on any sort of physical immutable characteristic and then treat members of that class differently unless there is some compelling reason for the differential treatment. So the Supreme Court has designated which classifications will be scrutinized And then the court's analysis is going to vary by the classification. But it's sort of an entrenchment of this general principle that of equal protection under the law, equality under the law. That is the analysis for civil rights cases. But let's now start talking a little bit more about civil liberties. Now that you see the distinction, the next section is just focused on these individual rights. As I mentioned before, there is no official list of all civil liberties. The framers of the Constitution knew better than to even try to identify a complete list of civil liberties. So instead, they enumerated some civil liberties that the national government would be prohibited from infringing. And in the Ninth Amendment, the framers made crystal clear that the liberties that they have identified are decidedly not a complete list of all civil liberties that deserve the protection of the Constitution. The framers did enumerate some civil liberties, however, and that enumeration is found in the original articles of the Constitution, in the Bill of Rights, and then in certain other amendments in the Constitution. But again, there are other civil liberties that deserve protection of the Constitution, and the Supreme Court has a system of identifying them just on a case-by-case basis. So these additional civil liberties are sometimes known as unenumerated civil liberties. And then the process of identifying them is known as substantive due process. We'll study substantive due process in a later module. But back to the enumerated civil liberties. So even in the original Constitution, the framers believed it wise to specify certain common law rights that would be protected. One of them is known as the writ of habeas corpus. And we've already talked about the writ in a prior module pertaining to the power of the president, and limitations on the government's authority to suspend the writ, except in extraordinary circumstances. So I won't rehash that here. But it doesn't end there. The original Constitution also saw fit to prevent both the national and the state governments from enacting bills of attainder or ex post facto laws. A bill of attainder is a law, a statute, enacted by Congress or a state legislature that identifies a specific person or group which have engaged in a specific activity that the statute defines as illegal and punishable. So if enacted and upheld, that law would bypass the due process protections of the judicial system. It would violate the separation of powers, and it would deprive people of their right to a jury. And that's the reason for this monopoly graphic, because bills of attainder send specific people straight to jail without the ability to challenge their incarceration before an impartial tribunal. So that's why it's like taking the power of the judicial branch away and trying to conduct that process legislatively instead. And it's also a violation of due process. So that's why the Constitution prohibits both the national and state governments from enacting them. Ex post facto laws are likewise unfair. They're just criminal laws or sanctions applied retroactively. That's kind of the translation of the Latin ex post facto. It means after the fact. So this is a prohibition on the retroactive application of criminal laws or sanctions. Article 3 also provides some protection for civil liberties. It requires a jury trial for all criminal prosecutions, and it also defines the crime of treason, even prescribing certain rules that must apply in treason prosecutions. So you can see the founders of the nation valued civil liberties, really valued them. And it limited the national government, and as I've just explained in a few instances, even state governments from infringing upon them. So if the founders so valued civil liberties, why did they not include a Bill of Rights, a longer list of the liberties deserving protection? There were several valid reasons not to include a Bill of Rights in the original Constitution, and you'll learn about this when you read Chapter 7. So I don't have a slide on that, and there's really no need for me to restate them, but you do want to pay attention to what those reasons were. We know that opposition to the Constitution during this ratification time period, the opposition was driven in large part by the lack of a Bill of Rights. And the very first Congress of the United States wrote a Bill of Rights, and then that bill was ultimately ratified in the first 10 amendments of the U.S. Constitution. In Module 7, I've included a link to a short video that reviews all of the Bill of Rights. It kind of gives the background for how they came to exist, and then it gives sort of a general elaboration on what is in each one of them. I'm going to read off this list, and I want to emphasize it's important for you to learn generally what is contained in each of these amendments. The First Amendment is going to cover freedom of religion, freedom of expression, and political behavior. The Second Amendment protects gun rights. The Third Amendment prohibits quartering. This is something we probably won't really study in this class. It had to do with a prohibition on quartering soldiers in one's home without compensation. Quartering soldiers would mean letting them stay in your home, like live in your home, feed them, do their laundry, let them accept them as a guest, but not being compensated for doing that. It was something that the British government engaged in after the French and Indian War that was really resented by the colonists. So in the Bill of Rights, we made a prohibition against that. And it's really a recognition of the sanctity of the home and the privacy of the home. The Fourth, Fifth, Sixth, and Eighth Amendments all relate to criminal procedure and criminal process. So the Fourth Amendment is the source of search and seizure law. The Fifth Amendment is the source of many due process rights. The Sixth Amendment is specifically about the rights of criminal defendants. The Seventh Amendment is the right to a jury in civil actions. So now Article 3 grants the right to a jury in criminal cases. And the Seventh Amendment expanded that to civil cases as well. The Eighth Amendment is famous because most people have heard of it because it has that prohibition on cruel and unusual punishments. But it also has some prohibitions on excessive bail and excessive fines. The Ninth Amendment emphasizes the fact that this enumeration of civil liberties is not intended to be any sort of exhaustive, complete list. So you see that written in the Ninth Amendment. It does not actually give any civil liberties. And then the 10th Amendment, likewise, it does not provide any or identify any civil liberties at all. It's just stating, kind of emphasizing the limited nature of the national government and the more plenary powers of the people and of state governments. So be sure that you study and learn what is generally included in all 10 amendments. And then in this module and in subsequent modules, we'll take a deeper look at these civil liberties. So each of the civil liberties that are enumerated in the Bill of Rights are protected from infringement by Congress, by the national government. Constitutional precedent upholds the principle that the Bill of Rights does not limit state governments, only the national government. At the time of its ratification, the national government was perceived as the principal threat to liberty. But as years passed, circumstances changed. The fight to maintain slavery and the continued subjugation of African Americans demonstrated that state governments were just as likely to threaten individual liberty. So shortly after the Civil War, we amended the U.S. Constitution to include several new protections, and these are known as the Reconstruction Amendments. The 13th Amendment prohibits slavery in any form by any person or government. So this is an issue. The ban on slavery applies to private citizens as well as the government. That's part of the 13th Amendment. The 14th Amendment accomplishes several things that your textbook outlines fairly well. Notice in particular that it includes a due process clause that is the mirror image of the due process clause found in the Fifth Amendment. It also includes an equal protection clause, which is something I'll discuss in just a moment. The 15th Amendment secures the right to vote for African Americans, limiting both the national government and state governments. Now look back at the 14th Amendment's reference to due process. It provides, nor shall any state deprive any person of life, liberty, or property without due process of law. What does that phrase mean, due process of law? And there are several modules that will explore the significance and meaning of the phrase, but for now, what you should know is that the 14th Amendment's Due Process Clause is the reason why state and local governments are prevented from infringing on civil liberties, individual rights. So the Bill of Rights does not apply to state and local governments, but because of this language here, and sort of the open-endedness of that phrase, due process of law, because of that, the state and local governments are likewise prevented from infringing on civil liberties. So the Bill of Rights does not apply to state and local governments, but the 14th Amendment explicitly does. Nor shall any state deprive a person, it says person, not a citizen, any person of their life, liberty, and property without due process of law. Over time, the U.S. Supreme Court has held that certain individual liberties, which happen to be enumerated in the Bill of Rights, are so fundamental that they are protected by that open-ended language, due process of law. And this is known as selective incorporation. The courts have selected specific civil liberties that are protected by the 14th Amendment's Due Process Clause, such that even state governments may not infringe them. As of today, there are only just very few, I think it's 3, civil liberties that are enumerated in the Bill of Rights but have not been selected for incorporation into the Due Process Clause of the 14th Amendment. One of them is the grand jury requirement. I believe the other one is the right to a trial in a civil case. The third one escapes me right now. But really all you need to recognize is what this process is. The courts uses the process of selective incorporation to identify which civil liberties are so fundamental to due process that they are protected by the 14th Amendment. There are other amendments to the U.S. Constitution that that enumerate civil liberties. I've got a few of them listed here. For example, the 19th Amendment guarantees women the right to vote. The 24th Amendment banned poll taxes, giving greater protection for the right to vote. The 26th Amendment lowers the voting age to the age of 18. And we've continued identifying new civil liberties and entrenching their protection in the U.S. Constitution through the amendment process. It has been used to specifically name additional civil liberties. But in addition to amendments, several of particularly the Reconstruction Amendments, include language in them that is referred to as an enabling clause. It's a clause that reads, Congress shall have the power to enact laws that carry into execution the principles of this amendment. It's called an enabling clause. So Congress has used that. Oh yeah, here's an example of one. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. So Congress has used that enabling clause to enact statutes that provide protection for civil liberties as well. And your textbook gives some really good discussion of some of those statutes that have upheld and protected civil liberties. So you see then, when we really, really want to protect the civil liberty, and there's enough political will to support that protection, we have a means of amending the Constitution to name and ensure that the civil liberty is protected. But we never have, and we probably never will, come up with a full and complete list of all civil liberties that deserve this protection. The Ninth Amendment makes that point clear. We don't have. It's not that no other civil liberties exist. It's just that we have only identified a few of them. So, what are the other civil liberties? How do we go about protecting them? I ask that question because of the way the Ninth Amendment is written. The enumeration in the U.S. Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What are those others? How do we protect them? That's what I was sort of referring to a few minutes ago. We use something called substantive due process. That is an analytical process that is applied by the courts. And so this is short of having an amendment passed. This is another way we have identified civil liberties and offered protection for them. We have in several instances recognized that a state's police powers ought to be limited in new ways. So as a society develops technologically, as our morals and values change, we develop new understandings of what is and what is not acceptable regulation of private behavior. Here's an example, kind of an extreme example, but at one point, this is true, at one point in the United States of America, state governments were permitted to forcibly sterilize mentally and physically disabled people. Now, we never amended the Constitution to recognize that as an individual right to be free from forced sterilization. But that liberty is certainly fundamental to freedom. So short of amending the Constitution, protection of unenumerated civil liberties is still provided through this analytical process known as substantive due process. So we'll look at that more specifically when we get into future modules. As I mentioned at the start of the lecture, most of the enumerated liberties that are in the Bill of Rights are explored in greater detail in future modules. But the Second Amendment is not. So I'm going to take a few minutes now to go into greater depth on the Second Amendment. The textbook does a good job of discussing kind of the state of the law at the time the textbook was published. But there have been some new developments on this amendment, and so that's why I'm going to add that to the material for this module and try to explain it to you through this module lecture. So here goes. The Supreme Court currently, so our current Supreme Court, currently places significant emphasis on the historical understanding of the U.S. Constitution's language. So the language, the actual words of the Second Amendment are extremely important for our purposes. The more conservative justices, we've got 6 of them now on the Supreme Court. The more conservative justices consider the meaning of the Constitution to be limited by what the original intent was of the men who wrote those words so in this particular instance, the Second Amendment. What did the people who wrote the Second Amendment intend by their words? When the Congress was debating the Second Amendment, this is in the late 1700s, 1790s, none of the states of the U.S. had a police force. Actually, a little trivia for you. The first official police force was established in 1838 in the city of Boston. So important for you to recognize that for personal protection, even for hunting, to get food that people needed to survive, people needed guns. So gun ownership was commonplace. It wasn't a controversial issue. You had to have a gun to defend yourself. There was no police force to come and do that. and then you had to have a gun in order to kill game to provide meat for your family. So gun ownership was essentially an accepted practice. It was common. Now, it's not to say there weren't any laws that created any restrictions on gun ownership. There were. Sadly, one of the worst forms of restrictions was a prohibition on African Americans owning guns. Some of the slave owning states passed laws that restricted that right. But overall, generally, all states and cities had some varying form of gun safety regulations. But other than those exceptions, pretty much anybody could own a gun at the time the Second Amendment was written. So the concern that prompted the Second Amendment was not public safety. Instead, it was government safety. Prior to the Constitution, America's military was entirely comprised of state militia. Militiamen were not full-time professionally trained soldiers. They were farmers and merchants who promised, and in some instances, I think, were actually required to step up and defend their state against attacks. So to have a militia then ensured a state's autonomy and sovereignty, its ability to defend itself from foreign attack, from the attack of another state, and even from the abusive powers of a national government. So that being the major concern of anti-federalists at the time, an abuse of power by the national government, the Second Amendment reflects this value placed on having an armed militia. And that is seen in what we call the prefatory clause of the Second Amendment, a well-regulated militia being necessary to the security of a free state. So there in that prefatory clause, you see what was really the driving force behind this amendment. Fear of the national government lay in its ability to steal power from state governments. And a state's only defense to a tyrannical national government was its militia. So the Second Amendment was an effort to prevent the national government from disarming any state's militia. So upon that historical context, many people argue that the Second Amendment does not ensure an individual civil liberty to bear arms, but instead is just an entrenchment of this collective right of a state to maintain an armed militia. But that argument is not complete, because that's not the end of the amendment. There's an operative clause that follows it. The operative clause reads, "The right of the people to keep and bear arms shall not be infringed." And there is a U.S. Supreme Court decision your textbook provides an explanation of called District of Columbia versus Heller, where the U.S. Supreme Court held that the Second Amendment's protection is an individual right, not a collective one. And then a couple years later, in McDonald versus City of Chicago, the Supreme Court extended that protection of individual gun rights even further by holding that the right is inherent in due process, and therefore it must be protected through the 14th Amendment from even state and local government infringement. So the textbook explains how the Supreme Court interprets the Second Amendment and the reasons why state governments are likewise limited in their power to regulate gun ownership and use. But after the textbook was published, the Supreme Court handed down two really important decisions. And those decisions relate to an issue left open in District of Columbia versus Heller, and then it was recognized, elaborated on a little bit in the McDonald decision. And that is, okay, so the Second Amendment prohibits bans on gun ownership. But what about, short of banning or prohibiting the right to own guns, can a state regulate gun safety? And there's nothing to suggest in the Second Amendment that a state can't regulate gun safety. People just have to have the right to keep and bear arms generally. So what was left open then is to what extent, how far can a state or a city go in the realm of gun regulation and not run afoul of the Second Amendment? So the names of those two cases then are New York State Rifle and Pistol Association versus Bruen, released in 2022, and then U.S. versus Rahimi in 2024. I've added some links to a couple of summaries and explanations of those two decisions in the module that you need to read very carefully so you understand the present state of the law. So, going back to my discussion about the importance of history, remember that is kind of the MO of the current court is to look to history. And that's what they've done in these two Supreme Court decisions. To answer the question is how far can a gun safety regulation go? The answer to that is they can go as far as states were going when the Second Amendment was written. So the court is going to look to the past to see whether there is a very similar gun safety regulation that existed when the Second Amendment was written. And if there was, we call it a historical analog. If there's a historical analog for a modern day gun safety regulation, then that modern day regulation would be upheld. So you'll see how that has played out in the Bruen case and then in the Rahimi case, and you'll see the process applied in a specific context. Okay, so that's really all that I see that I really need to address about civil liberties in the lecture. You should be sure to study all of the textbooks material on civil liberties very carefully. And if you find something that you would like me to explain further, please don't hesitate to send me an email or call me up on the phone. I'll be happy to hold maybe a Zoom meeting or something, some other arrangement to give greater explanation of any other civil liberty that is addressed there. But for now, for our lecture, we're going to move on to civil rights. Okay, it's our very next module, I believe. It's going to go into a lot of depth on civil rights law. So what I'm doing right now is just kind of emphasizing a few of the points. As I explained earlier, civil rights are collective rights. They belong to the members of groups, and those groups are most often minority groups. There may be reason to treat some groups of people differently than others. I'll give you an example. Children under a certain age should not be permitted to drink alcohol, and they should not be permitted to operate a car. They are not physically able to handle certain things. So it makes sense that you would treat people differently sometimes based upon their age. But other groups of people should never be treated differently. And so the Constitution supports the protection of these groups through the judicial process and also through the legislative process. The federal government is prohibited from differential treatment of certain groups through the Fifth Amendment's Due Process Clause. That's part of the Bill of Rights, and so it limits the national government. The 14th Amendment has a more explicit protection of civil rights in its Equal Protection Clause, and as we saw earlier, that amendment explicitly applies to state governments. But now we got to consider just for a second what we mean by minority groups. Oh, I'm sorry, I forgot. Here is a statement of what the Equal Protection Clause is in the 14th Amendment. No state can deny any person within its jurisdiction the equal protection of the laws. That's a very explicit protection of civil rights that's provided there in the 14th Amendment. But as I was saying, we have to take a look and focus. This is part of the analysis of civil rights laws. What groups deserve equal protection? So I gave you an example of a group that does not, and that would be young people. Age can be a legitimate reason to treat groups of people differently. But then there are other groups that should never be treated unequally. And when we're talking about minority groups, what we're talking about are groups of people who have been historically disenfranchised. These are groups who, for many years, were not allowed to fully participate in the democratic process. Their voices were not heard in government when some laws were written, so their needs and concerns they were ignored by the law that is being applied to them. And so because their interests weren't taken into consideration when the laws were enacted, the court has the power to go and ensure that to sort of right the wrong, to strike down laws that treat them unequally. Any differential treatment of people that is based upon their race, their ethnicity, gender, religion, etc., would be considered a suspect class or a quasi-suspect classification. And so the courts will very strictly scrutinize laws that treat groups or classes of people differently when those classifications are based on race, these physical characteristics that are immutable and changeable, not choice, not chosen. They would be classified as either a suspect classification or, in other cases, a quasi-suspect classification. And that classification then will determine the intensity of the scrutiny that the courts will apply. In addition to the Fifth and 14th Amendments protection of civil rights, Congress has also enacted statutes, enacted laws that protect civil rights. I previously mentioned that there were enabling clauses in various amendments that allow Congress to make laws to write statutes that protect civil rights. And their most known examples of that come from the Reconstruction Amendments, particularly the 14th Amendment, that authorized some of the civil rights laws that Congress wrote early on in our country. The Commerce Clause is another source of authority that Congress has used to enact civil rights legislation. So in our module focusing on Congress and the legislative branch, we looked at ways that Congress has regulated economic activity in such a way as to protect or provide for equal protection of minority groups. But both sources of power, whether it's an enabling clause in one of the Reconstruction Amendments or the Commerce Clause, both of them come with their own unique limitations. And so that those limitations are things that that the textbook explains fairly well. The Reconstruction Amendments, any statutes that are enacted under their authority requires state action. So you have to have a law passed by a legislature or an action of a government employee that has to be involved whenever a person is claiming a violation of the 14th Amendment or of the 14th Amendment, probably also the 19th Amendment. When they're using these enabling clauses, you've got to have state action involved before they would apply. The Commerce Clause, you don't have to have state action because these are areas where Congress is regulating private activity. But remember, when we were studying the Commerce Clause, the Supreme Court is kind of drawing back on the Congress's authority to use the Commerce Clause. And they've established 3 specific criteria in which Congress can act. So you have to consider those 3 criteria when you're looking at laws that are drawn out of the Commerce Clause authority. So both of those 2 different types or sources of authority and their limitations are explained in the textbook, and I'm not going to elaborate on them unless anybody needs me to and asks me to. I'll be glad to do it if you would like me to. But that's all I have for this module lecture for now, unless I hear otherwise from you guys. Good luck in the module and let me know if you need any help.